Good afternoon, everyone. It is 2 p.m. We're beginning the hearing. This is case number 2017-17515. It's been scheduled for today, beginning at 2 p.m. is defendant's motion for summary judgment. This motion has been scheduled for 30 minutes. Each side will have equal time. At 2:30, we are scheduled for plaintiff's motion for summary judgment. This motion as well has been scheduled for 30 minutes. Each side will have equal time. The court has reviewed defendant's motion for summary judgment, plaintiff's response, defendant's reply, along with plaintiff's motion for summary judgment and defendant's response. The court has reviewed all case law that's been cited to. These proceedings are being recorded on Zoom. Announce your presence.
Dr. James Eric McDonough, the pro se plaintiff, Your Honor.
Good afternoon.
Good afternoon.
Good afternoon, Your Honor. Matthew Mandel, Sam Zeskine for the City of Homestead.
Good afternoon. And I think we do have a court reporter also. Madam Court Reporter, if at any point you're unable to hear anyone, feel free to interrupt so you can have a full and accurate record. Okay, so scheduled for 2 p.m. is defendant's motion for summary judgment. As I stated, each side will have equal time, 15 minutes each side. Let me hear first from the defense, since this is defendant's motion for summary judgment. You may proceed.
Thank you, Your Honor. Matthew Mandel for the City of Homestead. Your Honor, this case was filed almost 4 years ago, relating initially to 3 public records requests out of over 100 or so public records requests that the plaintiff has submitted over the years to the City of Homestead. The plaintiff subsequently amended the lawsuit to add an additional 6 or 7 public records requests. Some of the claims were dismissed by Judge Ripple on May 21st, 2018. And then the plaintiff subsequently amended in June of 2018, serving a 60-page second amended complaint, naming 8 lawyers in my firm as defendants, a whole host of city employees as defendants, and including now 40 public records requests that he was challenging. We moved to dismiss the third amended complaint. And on October 18, 2018, Judge Ripple dismissed just about all of it with the exception of 2 requests. We'll call them requests number 4 and 6, and also plaintiff's challenges to excessive charges. So Judge Ripple also dismissed all claims for injunctive relief with prejudice. And really, the lawsuit has been boiled down to this. Regarding documents, request number 4 and 6 related to videos that were initially produced to Mr. McDonough, and then they were partially redacted, and they've subsequently been produced in an unredacted form. They were produced in an unredacted form late 2018. He also is challenging charges and relating to about 6 or so public records requests, and seeking broad, sweeping declaratory relief that goes way above and beyond challenging just the specific charges for those specific requests. So, Your Honor, the city is entitled to summary judgment, and I'll give the 30,000-foot view, and then I'll go into further detail. As it relates to 4 and 6, we'll call it the videos of those requests. Again, it's uncontroverted. Plaintiff has admitted that we have produced those videos in their unredacted form. The claims are moot. There was another request, we'll call it request number 2, where he's challenging that we charged him too much in an estimate, but the uncontroverted evidence and plaintiff's own admissions in response to our request for admissions demonstrate that he not only received the documents, but he received them at a much lower rate, paying a much lower amount of $18. There is a request number 5 that deals with a $5,000 estimate to obtain Facebook records, which, again, uncontroverted evidence that he withdrew that request. Request number 7 dealt with a certain personnel file for one of the officers at the city. He paid for those documents. He obtained those documents. And in fact, the city actually gave him a refund for some of the funds that it didn't need to use all the amounts that were paid to him. Again, uncontroverted on that. And then there were 2 additional requests. We'll call them 11 and 12. And his challenges as it relates to those requests are barred by the statute of limitations. Those requests were made 7 years ago, back in February 2014, and they weren't added to this lawsuit until well after the 4-year statute of limitations had passed for statutory causes of action, including under Chapter 119, the Public Records Act. So as there are no more issues to be decided, Your Honor, we feel that summary judgment is appropriate. So I'm going to drill down a little bit on requests 4 and 6 and why the issues related to that, those 2 requests are moot. Again, we produced these videos initially with redactions, redacting the identities of the arresting officers. They were arresting officer videos. Mr. McDonough challenged that, the redaction, and we've subsequently produced those videos in an unredacted form. That's uncontroverted. And he has admitted that in response to the request for admissions that we've also submitted with our summary judgment papers. So the production aspect is moot. And while the city is cognizant that simply producing documents in response to a public records request after a lawsuit has been filed does not automatically moot the case, it does here when we're dealing with a situation like Dr. McDonough, who is pro se, so there's no issue of attorney's fees. And there are no costs. And the reason why there are no costs, certainly if there were costs, that might not moot the case. But the reason why there are no costs is that Mr. McDonough added request number 4, his challenges to request number 4 and number 6, about a year or close to a year after he had filed the initial lawsuit in, I think, July of 2017. He added request 4 in his amended complaint in March of 2018, and request 6 is part of his second amended complaint in June of 2018. He has not offered any evidence or testimony that he's incurred any costs as a result of challenging requests number 4 and 6. So therefore, because we have produced those videos in an unredacted form, there's no evidence that we know he hasn't incurred attorney's fees because he's pro se. And there's no evidence that he's submitted in opposition to our summary judgment relating to costs that were incurred in challenging the redactions of 4 and 6. Those claims are moot. As to, we'll call it now request 2. Now we're going to get into the what we call the overcharge challenges. He claims that in response to this request that the city's cost estimate of $347.81 was excessive. However, as I mentioned before, the plaintiff has admitted that he paid for and received these records from the city at the cost of only $18.30. So what the plaintiff had done is, and we know that, and it's part of our request for admissions where we attach an article where he boasts about getting a high estimate from the city and that he circumvented that by having a conduit ask for the documents. At that point, the city had already gathered the documents, so all the city could do is charge the conduit the cost of copying, which is what they did. And Mr. McDonough has admitted that he paid for those copies and received the documents. That is undisputed. So he doesn't have any basis to challenge excessive charges once he's already received the documents and he received them for the copying costs. He doesn't assert that the $18.30 was improper.
Is there sworn testimony with regard to that admission?
It's a response to our request for admission, Your Honor. So he's admitted it as part of a response, which is akin to a sworn response. So he's admitted that. And specifically, if you want me to draw your attention to it, the request for admissions Look, number 4 and 5. If you bear with me, I can. Okay, just 1 second, ma'am. So number 4 was admit that you paid the $18.30 invoice provided to Jason Jensen by the city. Jason Jensen was his conduit. And that number 5, admit that upon payment of the $18.30, the city provided you with the responsive records. And he's admitted both of those. The next request is request number 5. And this is in regards to an invoice that the city had sent to him in the amount of about $5,100 and change for review of 53,000 Facebook records. It was a very, very broad request, basically asking for anything relating to the city's Facebook page. But it's also undisputed in response to our request for admissions that he essentially withdrew that request. What he was seeking was really the posts, comments, which were ultimately produced as part of another public records request. Actually, the initial lawsuit that was filed in this case, one of the requests that are at issue were seeking all the posts to the city's, I think, their police department's Facebook page, and those were relatively easy to retrieve, and those were retrieved and produced to Mr. McDonough at no cost. But the point is the challenge, the cost challenge that he's complaining about with respect to request number 5, he withdrew that. And again, when you go to requests for admissions 6 through 8, that he had sent an email, admit that you sent the email attached as Exhibit B, admit that Exhibit B is a true and correct copy of his email that he sent the city, and that number 8 says, admit that in the email attached as Exhibit B, you state that you did not ask for, nor do I want a copy of the 53,000 Facebook posts. So he's admitted that the cost estimate that we provided for those documents, he says, I don't want that. So now he can't come back here and say, and challenge the cost estimate for documents that he clearly doesn't want. I'll move to request number 7, Your Honor. That dealt with documents relating to a personnel file for an officer. He was sent an invoice for $325.56. He admitted that he paid that. He made that payment to the city, and that he actually obtained those documents. And he's also admitted that he received a refund from the city. The city actually gave him back about $28.67 because it didn't cost the city the full $325 to retrieve those documents. And it's true that an allegedly excessive charge can be a violation of Chapter 119, where it serves to inhibit the production of the documents. So if you're trying to roadblock somebody from obtaining documents by giving them a very high estimate, that has the effect of violating 119 because you're keeping somebody from the documents. But here we know he paid it, he voluntarily paid it, and he received the documents. So also there's something called the voluntary payment doctrine, which provides that where one makes payment of any sum under a claim of right with knowledge of the fact such a payment is voluntary and cannot be recovered. So because he voluntarily paid it, he received a partial refund, he obtained the documents. There's no claim here that it was done as a ruse to prevent Mr. McDonough from getting the documents that he got. We believe that summary judgment is appropriate as to what we'll call request 7. The last 2, which I'll take in tandem, Your Honor, which are requests 11 and 12, those are the time-barred requests. These are the requests that were submitted to the city back in February and March of 2014. There's no dispute about that. He alleges that in his complaint, his Fourth Amendment complaint. Keep in mind, we're on the Fourth Amendment complaint, this 5th iteration of the complaint in this lawsuit. And it's clearly barred by the statute of limitations. He admits that they were added into the lawsuit more than 4 years after the requests were made. That much is true. The argument is that they somehow relate back. And the reason why the relate back doctrine does not apply here is because it's not the same requests that we're talking about. It's not the same conduct or transaction. These are standalone, separate requests that Mr. McDonough, if he had an issue with them back in 2014, all the way up until the statute ran, had the ability to sue separately. They're not part of the same universe of requests that were part of the initial lawsuit. The initial lawsuit dealt with requests from 2016 and 2017. And now he's trying to pile on by going back to 2014 by saying, no, I brought a public records lawsuit, so it all relates together. And it clearly doesn't relate to the same transaction or occurrence. So to the extent that he's challenging the purported excessive charges for requests 11 and 12, those are barred by statute of limitations, and summary judgment is appropriate as to those requests. So as I mentioned, Your Honor, the request for injunctive relief was dismissed. Judge Raboul, in his order in October, or actually it was dated, I think, November 2nd, 2018, or November 3rd, was one of those. If you just bear with me, I'll give you the exact date of the order. November 1st. I mean, the hearing was
I have it in front of me.
Okay. So, and there were multiple orders that were entered that day. All of my law partners and lawyers in my firm were dismissed with prejudice. All the city employees were dismissed with prejudice. Virtually all the claims against the city were dismissed with prejudice, with a small little carve out, which was in paragraph 3. So the claims for injunctive relief are also dismissed with prejudice. And again, there's nothing to enjoin the city from doing here in particular. And let's see. And I think that's really about it. I think just from a argument standpoint, a lot of our arguments will be the same in terms of opposing Mr. McDonough's summary judgment motion as well. So however way the court wants to handle it, that's fine with us. But that's the basis for our motion for summary judgment, which, Your Honor, this is a public records case that has exploded and then has whittled back down to virtually a very limited amount of issues. And it's been about 4 years, and we believe strongly that we're entitled to summary judgment. I don't know if Your Honor has any questions.
Not at this time. Let me hear from plaintiff. Dr. McDonough.
Yes, ma'am, Your Honor. Thank you. A lot of issues here. I want to treat opposing counsel with respect, but I take issue to his fanciful description of the facts and how things went down. I also object to any unsworn statements he's made, as unsworn statements of counsel are not evidence. And the City of Homestead has placed no evidence on the record whatsoever that was sworn testimony. At our first hearing in this case on July 31st, 2017, the Honorable Judge Bailey said that we would go back to another hearing to determine the reasonableness of cost for Request 2. Request 2 was in the initial request and what cost me to file the case. So that leads into my next counter to what Mr. Mandel said, is I am entitled to cost if they're found to unreasonably violate the public records law. They have not given any defense or provided any justification for their excessive charges that were provided in Request 2. On the evidence, I've submitted records that I got from the city, including their fee list and their IT salaries, and it shows that there's no combination of any cost that equals $45 an hour for IT time. Furthermore, at the first hearing on July 31st, which I have the transcript here, opposing counsel admitted that 5 hours was not for IT time, but 5 hours was actually for the clerk time, which is a much lower rate. Therefore, that is excessive. Furthermore, they can't justify or have not provided any justification for the amount of time it took, and I'm requesting that that was excessive. So they charge a rate for request 2 that's not based on the actual cost of production or on a labor cost, which is required under Florida statute. I'm alleging that they've inflated the hours needed to do the request, and they've improperly charged me for copying fees when the records are electronic and they've been requested electronically. All these add up to make excessive charges that do serve to inhibit. The fact that I have well enough finances that I can actually pay some unreasonable and excessive charges does not mean that I'm not inhibited or that their actions don't inhibit others. They have a policy of charging $45 an hour, and they've charged us for almost a decade now. When we had the first hearing July 31st, 2017, Judge Bailey told Mr. Mandel to provide me with a fee list they used for responding to public records requests. Mr. Mandel agreed. Mr. Mandel then blocked me for over 2 months from getting a fee list, requiring me to get an amended order, forcing me to get the fee list. He then stalled for several months before he gave me the fee list and gave me the 2017 list, not the 16 list he was supposed to require. Mr. Mandel and his colleague Samuel Zeskine have created many delays in this case that they then go and use to blame on me. I will admit that we are on the Fourth Amendment complaint. After the initial complaint itself, we had a hearing. I was told to go and amend, so I went and amended. We had another hearing with Judge Rebold, who told me to amend to clarify. I amended trying to clarify it, but I also added, admittedly, additional records requests to show what I was alleging was their pattern of violations. I then filed the third amended complaint only to correct Scrivener's errors. There was no difference in any scope of amendment, the Second Amendment versus the Third Amendment. When we went in front of Judge Rebold again, he cut out many of the types of claims for declaratory relief I was requesting, and because of what he's done, it got cut down from over 40 requests to now 7 requests that we have to deal with. I also like to notice that the order given by Judge Rebold at the last hearing on motion to dismiss, on city's motion to dismiss, did not say that all claims for injunctive relief were barred with prejudice. I completely disagree with that. Further, I'd like to also address, well, before we get any further, I don't want to take up too much of your time, Your Honor. I've been told that I was going to get a hearing to determine the reasonableness of the cost, and this case cannot be dismissed without having an evidentiary hearing to determine if records were unlawfully refused and if I'm determining my cost of enforcement. Mr. Mandel knows that. Mr. Mandel was opposing counsel against me in another public records lawsuit that the 3rd District remanded back last year in 2020, stating the exact same thing, that you cannot dismiss a case under public records filed under 119 unless there's been evidentiary hearings to determine cost and lawfulness of the request. Mr. Mandel completely knows this. I have no idea why he would pretend that this is not the case or that he's not aware of this. With that said, I don't think that he's entitled to have my case dismissed before we have evidentiary hearings. Regardless, I believe that's a reversible error, Your Honor. I'll try to quickly just go through some of the other requests to kind of counter some of his arguments. Request 5 was for Facebook records. I will pull this up now. The Facebook records I requested, their response was for 53,000 Facebook posts, messages, and comments. My records request did not ask for any Facebook posts, messages, or comments from their Facebook page. My request was very specific. I asked it for documents and records related to how the page was managed, what was allowed to be posted, what was allowed to be commented on, what was their policies for deleting comments. Quickly, I'll notice that Mandel was in the deposition with Zachary Good, who was in one of the other requests in this, and he admitted to hiding and deleting my comments from Facebook, which is censorship. And so I was trying to get records related to any policies they have, any documents they have. If you look at Request 5, it very clearly states that they try to charge me over $5,000 for 53,000 Facebook records. I admit that I sent the email to Mandel. I admit in the request for admissions, I sent that email to Mandel. I wholly deny that I withdrew my request. What I stated very clearly was I did not ask for any Facebook posts. Mandel wants to play games with that, but my request was very clear. I wasn't asking for posts. My response was very clear. I was not asking for posts, and I never withdrew my request. Furthermore, the city has never said that the records that would be responsive to request 5 have been produced or don't exist, so it can't be dismissed further for that reason. With request 7, me asking for the personnel file of Bobby Kennedy, opposing counsel argues that I was given a refund on this, so I can't argue the cost. First, I'd like to say the big argument on this is they're charging me for paper copies when the records are electronic, and I've asked for electronic records. If you look at the invoice with this request, they actually charged me to print the records for redaction, even though they gave me the records electronically. And not only do they charge a copying fee, they also charge for their time to print the records, which is double billing and also not allowable under 119. It makes the request unlawful. I contest the amount of time they spent on the records, even with the reduced amount of time. And in this request, I'm alleging they inflated the hours. Again, they improperly charged me for copying fees. And another issue, they failed to waive the first 30 minutes of production. If responding to a records request requires extensive use of IT time, resources, or clerical time, they're allowed to charge an extensive service fees. The statute doesn't specify what extensive is, and every municipality makes up their own policy. City's policy is that they waive the first 30 minutes, and they've done that for some of my requests, but many of my requests they haven't, which is, again, they're unlawfully charging me excessively for costs. With respect to requests 11 and 12, opposing counsel says they're barred by the statute of limitations, and I do admit that when the amended complaint adding them was filed, this 4-year statute of limitations had expired and ran. However, they should be added in due to the relation back doctrine. The relation back doctrine, as Mr. Mandel has put on the record here, states that if the initial complaint tried to set forth any conduct, transaction, or occurrence, if you read my initial complaint, I very clearly set forth that I had filed approximately 100 records requests, and that the City of Homestead had unlawfully refused and cooperated in myriad types of violations with the overwhelming majority of those requests. It should be fairly clear that my initial complaint meant to set forth the same conduct that requests 11 and 12 set forth. Furthermore, the 3 requests that were contested also had some of the same overcharging problems. Sorry about that. So I believe it's disingenuous, and if these records are for requests 11 and 12 are determined or declared unlawful, it's not like a separate claim. The city I don't get extra damages. What I'm trying to do is the city, I believe, has dozens of different tricks they play to prevent me from getting public records, and I want those tricks to be declared unlawful, and if we can show a pattern and an expectation that they will continue in the future, I would request an injunction. With that said, I really don't have much more to say, Your Honor, other than this case can't be dismissed until we have evidentiary hearings, and opposing counsel is very aware of this.
Plaintiff, with regard to request number 5, the Facebook records, is it your position that the city turned over those records? I understand their position is that you withdrew your request, but what is your position with regard to the Facebook records?
I'm sorry, Your Honor. Let me clarify that. I might have made that a little bit confusing. So request 5, I requested specific documents related to the Homestead Police Department's Facebook page. Not Facebook posts, but documents related to the management thereof. City of Homestead wanted to charge me over $5,000 to review the 53,000 documents on the Facebook page. At the first hearing in this court, as Mr. Mandel admitted, they gave me the complete records of the City of Homestead's Facebook page, the mayor's Facebook page, and the Homestead Police Department's Facebook page, all for free, and he said it wasn't very hard for them to get it to me. So why would partial records from just the Homestead Police Department cost $5,000, particularly when it's clear those were not the records I had requested, Your Honor?
Okay. Anything else?
Your Honor, may I address?
No, I'm asking plaintiff first. Anything? Sure. Anything further?
I rest my case, Your Honor.
Okay. A brief rebuttal.
Sure, very brief. Right. He's regarding the request 5, Your Honor. It wasn't just relating to Facebook posts. It was relating to basically anything and everything relating to the city's Facebook page, which is far more than posts. There's a whole, it was much broader than that. And the request, as we interpreted it, would have cost $5,000. And he said, I don't want that. That's not what I want. So we said, okay. So the reason why it's moot is because the estimate for which he is challenging is for something that he didn't want. And he is separately, and he's admitted that just today, that what he wanted when he did another request for Facebook posts, that was very easy to pull. But when you're asking for Facebook and anything and everything relating to a Facebook page, posts are only a subset of that. So he was seeking far more than that, which is why it required extensive time. But he has since admitted that once he narrowed his request, and he did it in a separate request for posts, that was produced. That was part of his initial lawsuit, in which we, at the hearing on July 31st, 2017, before Judge Bailey, we gave that to him, and he's admitted that on the record. As it relates to his issue about he needs to have a hearing, I think what he's referring to is under Chapter 119.11, when you file a public records lawsuit, you're entitled to have a hearing to determine whether any documents have been withheld. The prior case that he is referring to is a case where, and he's filed many different public records cases. Right now we have 4 pending public records cases, 2 before Judge Rodriguez, 1 before Judge Acharte, and 1 before Your Honor. And one of the cases before Judge Rodriguez, it was the petition for writ of mandamus that he filed was denied without a hearing. And we agreed he was entitled to a hearing. In this case, when he filed his lawsuit in July of 2017, guess what? He had that hearing. In fact, he has attached a transcript of that hearing, that hearing that he's entitled to as a matter of right. That is attached as a transcript to his reply. So he got that hearing. It's just a red herring argument, what he's saying now. And then, again, a large focus of his arguments relating to what we'll call Request 2. He keeps talking about the city and the rates that we've charged and whatnot. Again, he keeps focusing on the $347 charge that he claims is excessive, but you notice that he did not address the fact that he has admitted, again, in response to a request for admission, which is a tacit admission, which is appropriate evidence at summary judgment, that he paid for the documents at $18.30 and received them, and he has not claimed that the $18.30 copying charge is improper. So those are just my responses. I don't know if, I don't know if there's anything else really to address in terms of his summary judgment motion, but these are all the issues that are currently pending.
I will now hear argument on plaintiff's motion. Yes.
Could I have 1 or 2 minutes just to show you a couple things real quick, since we're supposed to get equal time?
As it pertains to defendant's motion for summary judgment?
Yes, ma'am.
So procedurally, I allow the party who has filed the motion first. Then I give the opposing side equal time. And then I give the other side rebuttal. I've already given both sides an opportunity. So this concludes the motion for defendant's motion for summary judgment.
Yes, ma'am, Your Honor.
And now we begin plaintiff's motion for summary judgment. That motion as well is set for 30 minutes, of course, unless the parties wish to use less. Each side will be given equal time, 15 minutes. I will hear first from plaintiff, since this is plaintiff's motion. And as I stated at the beginning, I have read the motion and the response in all cases. Dr. McDonough, I'll hear from you first.
Thank you, Your Honor. May I share my screen to show request 5?
You may.
Let me see how to do this. Give me just 1 second. Okay, Your Honor, you can see this is request 5, and it specifically asks for copies of documents and records related to Homestead HPD or Homestead Police Department's Facebook page. 1, who controls, monitors, deletes, etc. 2, rules, regulations, guidelines. I'm sorry this thing is in my way. established for updating and deleting content and controlling access to post, comment, like. 3, under whose orders or directions were my posts deleted and access denied or restricted. 4, what is the legal justification for such deletions and restrictions? 5, why have entire posts, not just comments, been taken down? 6, why was the review section taken down? In their response, they also noted that several of these were questions and not properly requests for records, and they did not answer them. But you can see very clearly here, there was no Facebook post that was requested. If the city is alleging there's 53,000 pages related to how they manage their page, I don't know how or why those would be exempt. They haven't claimed any exemptions, or why it would take so much time to review. Even assuming arguendo that opposing counsel's argument is correct, that my request 5 does ask for a Facebook post, the Facebook posts have already been publicly published. The city itself published them to the public. It can no longer claim an exemption, and to charge me over $5,000 to review those is just absurd. Additionally, opposing counsel continues to try to make hay of the fact that I supposedly went and picked up the records for Jason Jensen. I admit that I went and picked up the records for Jason Jensen. I admit that I paid his invoice. I absolutely deny that I requested Jason Jensen to file the records request. He did that all on his own cognition. I had no control over that. After he filed his request, the city gave him an invoice for $18, which he provided to me. What's very important here is the request that Mr. Jason filed, as well as the invoice that city provided to Mr. Jason, was not based on request 2. It was based on another request, which I had labeled earlier as request A. Request A was litigated in another case, in case number 2016-012412. In that litigation, opposing counsel in the city stated that there were only 5 responsive documents and that all of them were exempt. Mr. Jensen did not file request 2. Mr. Jensen filed a separate request. At the first hearing on July 31st in this case, they then said that the records that they had given to Jensen would be responsive to my request 2, and at that point I waived further production, but Judge Bailey was very clear on the record that we needed to have a hearing to determine the reasonableness of the cost. Judge Bailey set forth very clear rules for what Mr. Mandel was due to help determine if those costs are unreasonable, and Mr. Mandel has absolutely failed to do them and has refused to do them in many instances. So I want to make sure that we had that record clear. Overall, there are 7 public records requests that are contested here, and there's at least 5 different violation types I'm alleging. I'll start and break them up. A has to do with improper redaction of video. When they claim an improper exemption to redact video, first, it creates an affirmative unlawful refusal to produce all public records as required under Florida Statute 119.01, Section 1. Further, charging me for time to do a redaction that's not supported by exemption is additionally overcharges. With respect to request 4-1 and request 6, I admit that City of Homestead has finally given me unredacted copies of the records. The problem with this is City didn't produce those unredacted copies of the records until months after I filed them in an amended complaint, years after the initial requests were actually filed. If we go back to request 4.1, this was filed on September of 2014. I filed a request and the city charged me $400 and some. I was filing the request for a school teacher who had been arrested and thought that she had been falsely arrested, and I was trying to help her get records. I wasn't going to pay $441 for the records, so I told her she should try to request it herself and see what happened. She requested herself. I believe they produced redacted video for $13. She then sent a letter to Samuel Zeskind, opposing counsel here, asking why they were redacted, because the redaction claimed 119.071 4D does not support redaction of video. Zeskind responded with his own letter citing Ramsey v. Demings to support redaction of video. However, Ramsey v. Demings wasn't based on 4D, it was based on Section 3, which is any information that reveals the identity of an undercover officer. They never made that claim. Their case law doesn't apply to this claim. At the last hearing on motion to dismiss, Judge Riebel made it clear that it did not apply. If you look at the section of 119 that has the exemptions, many places in that section recognize the difference between film, videotape, autograph, video data, photographs. But when the legislator wrote exemption 4D, they specifically held it only to photographs. The exemptions have to be very narrowly construed to what they exact say, and it's opposing counsel or city's burden to prove that they're entitled to these exemptions. City now produces the unredacted video and says, hey, we gave them unredacted video, so the case is moot. City continues to argue that they did not unlawfully refuse the records, and if the exemption is proper, why are they now giving me unredacted videos that are properly exempt? They haven't explained that. It's all smoke and mirrors, Your Honor. With that said, I think with what has been said so far, I've pretty much laid forth my grounds that the city has improperly responded to my request and that I should be entitled to declaratory relief. I've submitted affidavits for all this. I have contested all of their affirmative defenses, and I really don't think there's much else to do. I will concede to opposing counsel's argument that we cannot dispose of injunctive relief at summary judgment, and therefore I would request, as I did in my reply, that this either be converted to an evidentiary hearing or we set the evidentiary hearings necessary in the future so we can finish this case up and get this out of everybody's hair. And with that, I'll save the rest of my time for opposing counsel to rebut.
Does your count for injunctive relief and declaratory relief, does it differ in any substantive manner from the petition whereby those two counts were dismissed with prejudice?
Which two counts were dismissed with prejudice?
Your count for injunctive relief and for declaratory relief.
City had filed opposing counsel had filed 3 motions to dismiss. They filed one for the city attorneys, they filed one for the city employees, and they filed one for the city. The city employees and the city attorneys were dismissed with prejudice. The claims against the city for the improper redaction of video and the excessive charges were not dismissed with prejudice, Your Honor.
Okay. Thank you. Anything else, Dr. McDonough? And I'll give you some rebuttal time, but anything else with regard to your motion?
Rebuttal. Thank you.
Let me hear from defense.
Yes, Your Honors. While we're looking at request 5 that's up on the screen. As you can see, the request is copies of documents and records relating to Homestead Police Department's Facebook page. It's very broad. It's not limited to just posts. Again, the documents that we ultimately produced easily were when he narrowed his request to just posts, and he has those. But as you can see, it's an extremely broad request, which is what prompted the estimate. But again, it's all moot because for what the estimate that he's challenging are for documents that he doesn't want, and he's basically said, I don't want those 53,000. So again, just to address that, I also think that it's important. In Your Honor, we attached an email exchange between Mr. McDonough and his conduit, Jason Jensen, when he says Jason Jensen did it all on his own. Your Honor, if you look at the request for admissions that we attached, that he's admitted are true and correct copies of emails that he had with Mr. Jensen, I mean, you'll see that this. I'll highlight some of the dialogue. Mr. McDonough says to him, I will happily pay the fee if you get the records. That saves me $329. That is awesome. 3 minutes later, plaintiff writes, they will claim they only charged the first person. I have done this before. I asked for records. They came back asking for $450. I had another person file it, and we got it for free. If they tried to charge you for the redaction time, it'd be double billing. And then finally, a little bit later after that, a few minutes later, he says, they will claim the fee for the time spent for me, whether I paid it or not. However, this is what's important here. By picking up the records for you, I get around paying that fee. So it's clear what he was doing here. And the fact that he says, oh, my buddy just got it on his own. I mean, we know what's going on here. He got an estimate, he tried to circumvent that, and he did. And he got him for a lot less than he's claiming. So he can't sit back and say, oh, the estimate was super high, when he himself was able to get around it and pay a lot less, which he's admitted here today, he's admitted his request for admissions, and he's obtained the documents, which again, he's admitted it here today, he's admitted it previously on the record. It's actually in the court order from Judge Bailey on July 31st, 2017, and he's also admitted it here today that he has those records. So that's just all. He likes to use the word smoke and mirrors for him. The issues that he's talking about for requests 4 and 5 about the redaction and the videos, he's admitted he has those videos. So again, to the extent that he's challenging that they were improperly redacted, that issue is moot. The only thing that could keep those claims alive is if he had a pending claim for costs relating to the production of those unredacted videos. Now, we are cognizant of the fact that just because you produce something, that doesn't moot the lawsuit, but it moots it in this case because Mr. McDonough has not offered any evidence that he's incurred any costs as part of the underlying litigation in which the city has produced the unredacted videos. We know that he filed an initial lawsuit relating to other requests and then piggybacked that lawsuit with the video requests. So he has not gone on the record and has offered any sworn evidence that he's incurred any costs relating to obtaining the unredacted videos for request number 4 and 6, and therefore those claims are clearly moot. And again, I'm not going to go through the whole, my argument again about the overcharging request that he's talking about, because it's my same argument. The same arguments is that, that he relating to number 7, the voluntary payment doctrine, and numbers 11 and 12, they are clearly barred by the statute of limitations. He's admitted that here on the record. They do not relate back. They are separate requests relating to separate documents. And the fact that
I'm having difficulty hearing you.
I'm sorry, Your Honor. They're separate requests relating to separate documents that are, 2.5 years prior to the other requests that formed the initial basis for his lawsuit. So they don't relate back. So with that said, he hasn't shown, first of all, how there are undisputed facts that would resolve the case in his favor. I haven't heard why he's entitled to summary judgment, but you have heard plenty as to why the city is entitled to summary judgment. So unless the court has any questions, we'll conclude our
You have argued that the count for injunctive relief and declaratory relief were dismissed with prejudice by the previous judge. Did those counts mirror what's before this court?
Very similarly, Your Honor. In fact, when you look at what Judge Ribul's order was very...
I have it in front of me.
Yeah, it was very clear that, again, with the exception of the claims identified in paragraph 3 of this order, the claims brought against the city in the plaintiff's third amended complaint, including but not limited to the claims for declaratory and injunctive relief, are dismissed with prejudice. And then the carve-out was only his claims against the city relating to requests 4 and 6 are dismissed without prejudice. Claims against the city relating to alleged overcharges are likewise dismissed without prejudice. And that's again, Judge Ribul basically narrowed the pending issues to just the overcharges and the 2 outstanding requests 4 and 6, because at the time the city hadn't produced the unredacted videos. Subsequent to this hearing, the city produced the unredacted videos. So we're talking very narrow, limited issues that remain pending. No more injunctive relief, no more declaratory relief. The declaratory relief would only be to the extent that he's challenging specific overcharges for specific requests. No more than that. Everything else is gone. That's our understanding of the ruling.
Okay. Rebuttal.
Yes, ma'am, Your Honor. First, I'd like to state that assuming that opposing counsel's description of request 5, which you see here, is broad, he reads, as he stated, he reads it as copies of documents and records related to Homestead's HPD's Facebook page. Period is how he interpreted it. It should be very clear that I've asked very specific things about the page. My number 1, 2, 3, 4, and 5, 6 are specifically related to what I was requesting. Assuming for arguendo that they interpret that to be what I actually asked for, plus all the other things, it still doesn't justify how they're charging to review things that they've publicly published. Now, switching gears to what he was talking with my emails to Jason Jensen, I'll admit that those emails that he says say what they say they do. I provided them to him. An important thing to note is Mr. Mandel filed his request for admissions after I got a protective order against discovery because him and his partner Zeskind had made false statements on the claim to try to abuse me in discovery. The reason I responded to their request for admissions is I thought that they were going to also cooperate and request or respond with my discovery. However, they did not do that. One time, I actually even subpoenaed the witnesses so I could depose them, and they completely didn't even show up to the subpoenas. This was after the amendments. That's another cost that I have. Opposing counsel argues that I've offered no evidence of cost on the record. Maybe I'm confused, but I've never seen anybody offer cost of evidence on the record until after the case is dismissed and you're fighting for cost. If I need to make an affidavit or if I can swear under oath now that I have cost before, during, and after the filing of the initial complaint, I'm happy to do that. Mr. Mandel would like to ignore that. But again, what's really clear is the records request that Jason Jensen filed is not the request that I filed. It is a different request. Their request has still not been given to me. They admitted at the hearing that the records were given to Jason and that they were Jason records, not my records, Your Honor. I admit that I paid Jason's invoice and picked his records up, but not only is it Jason's request, not my request, it wasn't request 2 that was filed. And where opposing counsel talks about the claims being dismissed with prejudice, if you read that closely, what the judge is saying is all my claims, including declaratory and injunctive relief, for the roughly 40 requests that were dismissed, are dismissed with prejudice. If my claims for declaratory relief and injunctive relief are dismissed with prejudice for the recording redaction and for the overcharges, why are we even here? It's absurd that opposing counsel would even say that. Further, I note that they still have not provided me any records for request 5, and I've never withdrawn request 5. I contested their charge, and I contested what they were trying to produce, and they don't want to deal with it, and all they want to say is that I withdrew it, which they know is disingenuous. With that, Your Honor, I don't want to take up any more of your time, so I'll rest my case, unless you have any questions. Or,
I did have one question again, and perhaps I did not understand your answer. Dr. McDonough, is it your position that request number 5 was turned over?
No, ma'am. That's another misleading statement made by opposing counsel. They gave me the entire history of the city's Facebook page. It wasn't in a clarified request. It was in a completely separate request where I asked for the entire Facebook histories of all 3 pages. It was not this request 5, Your Honor. And none of the records I was actually seeking in request 5 have ever been provided to date. Again, because they haven't been provided, until they're provided or the city comes on the record saying that they don't exist, the case cannot be dismissed, Your Honor, respectfully.
Okay. Thank you to both sides. And thank you for uploading in the appropriate fashion both motions and the responses and replies. In Cookston versus Office of Public Defender, the plaintiff petitioned also included a request to be reimbursed for costs consisting of postage, envelopes, and copy of costs. The Fifth District Court of Appeals held that the petition was not moot because the court not determined whether the plaintiff was entitled to reasonable costs of enforcement pursuant to Florida Statute 119.112. The appellate court reversed and remanded the trial court to determine whether delay in providing the requisite records constituted an unlawful refusal, entitling appellant to an award of costs. See Clixton at 204 Southern 3rd at 481. In Mazer v. Orange County, 811 Southern 2nd, 857 Florida 50 CA 2002, the 5th District Court of Appeals reversed and concluded, although the production of the code rendered moot plaintiff's request for the code, it did not render moot his request for attorney's fees under Florida Statute 119.12. The purpose of 119.12 is to encourage public agencies to voluntarily comply with the request of Chapter 119, thereby ensuring that the state's general policy is effectuated. In the case at bar, request number 4 and request number 6 were turned over by the defense after the initiation of the original complaint. Pursuant to Mazer v. Orange County, defendant's motion for summary judgment is hereby denied. The court shall have a hearing to determine whether delay in providing the records, the requested records constitutes an unlawful refusal, entitling the plaintiff to an award of costs. As it pertains to request number 5, copies of documents and records related to Facebook page, the court hereby finds there's a genuine issue of material fact as to whether these records have been turned over. Moreover, pursuant to Mazer v. Orange County, a hearing shall be conducted for the trial court to determine whether delay in providing the requested records constitutes an unlawful refusal, entitling appellant to an award of costs. As it pertains to all other remaining counts, relying on case law cited to by defendant, motion for summary judgment is hereby granted. The court, after reviewing plaintiff's motion for summary judgment, along with defendant's response, hereby denies plaintiff's motion for summary judgment, relying on all case law cited to by defense. I need 2 orders to be uploaded onto court map. Dr. McDonough, do you prefer to email the court your, because on your motion for summary judgment, you can email the court your proposed order. Do you wish to do that?
I can do that, Your Honor. If you prefer me to upload it by court map, I'm happy to do that. Whatever is most convenient for you.
I would prefer court map if that is okay with you.
I'm happy to do that for you, Your Honor.
Okay, please send a copy, and that's only as to your motion for summary judgment. As to defendant's and plaintiff's motion for summary judgment was denied. Defendant's motion for summary judgment was denied in part, granted in part. Defendant's motion for summary judgment, please upload it by the defense onto court map as well. Exchange orders before you upload it to court map. Any questions?
I just want to make sure that I understand you. You said for requests 4, 5, and 6, you're denying them, but then all other requests, which would be requests 2, 7, 11, and 12, you're granting their motion for summary judgment, Your Honor?
As to 4, 6, and 5, defendant's motion for summary judgment is denied.
Denied, okay. Excellent.
Any other questions?
I just want to make sure I heard you.
Any other questions?
No, Your Honor. Thank you.
Okay.
Your Honor, I've had problems in this case.
And I'm sorry, could you stop sharing just momentarily,
I'm
please?
I'm sorry.
So I can see you all better.
I'm sorry. I'm new to all this.
I can see you now.
I've been having problems in this case and the other 3 records cases. Opposing counsel has refused to cooperate in good faith to confer to schedule hearings. If he refuses to schedule hearings with me in the future, can I just send something to you to make sure we can get our hearing and get this case out of your hair, or how would you like me to deal with that?
So the procedure that I ask all parties to abide by is the following. If the matter is appropriate for the motion calendar, and motion calendar are matters not evidentiary in nature, and matters that I can rule upon in a total of 5 minutes,
Okay.
2.5 minutes per side, and I'm very strict on the time. So if it is a matter that is appropriate for the motion calendar, all that is required is an attempt to meet and confer, which means you email the other side, and then you notice the matter. But my website instructions require 7 working days for notice. So all that is required for a matter that's for the motion calendar, which is just 5 minutes total, is an attempt to meet and confer and notice via court map 7 working days. If it's a matter which is a special set hearing, such as this, any matter that's more than 5 minutes, or any matter that's evidentiary in nature, you have to fill out the form. One of the requirements of the form does say that you have met and confer. I recognize that sometimes it is difficult for both sides to meet and confer. And therefore, on those circumstances, essentially, if you need a hearing, you put it on the motion requesting a hearing date. So you notice it on the motion calendar, where all you need to do is attempt to meet and confer via email in 7 working days. And the motion would be motion to request a hearing.
Excellent. Thank you so much.
And then I'll hear from both sides, and then I give you a date on that motion date. So the quickest way to get to the court is by properly noticing a motion for the motion calendar, but with the understanding that you can only notice matters that are appropriate for the motion calendar. But if it's to select a date because you all can't agree, I will assist both sides and select that date.
Thank you so much for your time today, Your Honor.
Okay. Have a good day. Stay safe. Please keep washing hands.
Thank you.